Welcome to the Indian Journal of Law and Public Policy podcast.
Hello everyone, welcome to the second season of the IJLPP podcast. I'm your host Pranav Tanwar, consulting editor at IJLPP. Here we discuss major happenings of the legal and policy field. Today, for the sixth episode, we have a very special guest, Mr. Debanshu Mukherjee. Mr. Debanshu is one of the co-founders at Vidhi Centre for Legal Policy. Currently, he is the lead at corporate law and financial regulation. He was instrumental in advising the government on the design and drafting of the Insolvency and Bankruptcy Code, and that is where I am going to interact with him today. Thank you, Mr. Debanshu, for taking out time, and I welcome you to the podcast.
Yeah, thank you so much for inviting me, Pranav.
So, beginning with a slight background to your professional life, before we move to legal developments, as I said already in the intro that you were actively involved in the drafting of IBC. Also, you were a member of a government-appointed committee for operationalizing the NCLT, and you have deposed before two parliamentary committees as well, and was even present during the parliamentary proceedings when this code was passed. As I can understand, that is quite fascinating from the view of an outsider observing this interaction between legislative and research think tanks. If you could share your experiences or challenges during these interactions.
So it was a fascinating experience, and when we started with we really had no expectations of what kind of work we'll get, but we were fortunate that we were called to advise the government on this large reform project. And the way this started was, we first prepared a concept note early in March 2014, and and at that time it was the UPA that was in power, and we went and met some officials in the Ministry of Finance, and they basically asked us to come back after the elections. And then soon after the elections, we went back to them and presented this idea, and we said that bankruptcy law is one area where the system appears to be completely broken and a lot can be done. And so some of them bought into the idea, and soon, in a couple of months, we saw that the government in its budget declaration had kind of announced that they would be, it's looking at developing a ecosystem for a separate bankruptcy regime for micro and small enterprises. Soon after that, a committee was set up, and we were appointed to advise the committee on the design and drafting of the law. And interestingly, by this time, the project had actually expanded beyond MSMEs, and the government was now looking at reforming the entire bankruptcy law ecosystem. And it was a very fascinating exercise. As I said right at the outset, there were a lot of senior professionals who were part of the bankruptcy law reform committee. There were senior government officials. Dr. Raghuram Rajan, who was the governor of the RBI at that time, he also came and interacted with the committee members in between. So the entire experience was highly enriching, and while we were kind of doing all the research for the committee and kind of taking the lead in the beginning, it was a big learning experience for us as well, in terms of the expertise that a lot of other stakeholders in the committee brought to the table. And then the committee divided its work in two parts. They first released an interim report, and then and after that a final report was issued along with the draft bill, and this was sometime around November 2015. And soon after that, the government tabled the bill in the parliament, and we continued to assist the government throughout, right up to its enactment in May 2016, and we also advised them on the implementation of the law after that. So overall it was a brilliant experience.
That was really interesting to hear the entire process, and thank you for sharing them too. Hopefully we will keep seeing this interaction. Now moving to more contemporary developments on IBC, and no doubt most vital of them is the suspension of IBC section 7, 9 and 10 through insertion of section 10A via an ordinance. So Mr. Debanshu, ordinance seems to have certain issues, and one among them is that it puts a blanket stay on bankruptcy proceedings. It has taken into garb limitation on debtor companies voluntarily wanting to submit itself to the insolvency process, or if insolvency is not due to COVID-19 crisis. So do you think this measure of suspension is slightly excessive?
This suspension should be seen in light of the overall political environment. And, it's not, although bankruptcy is seen as a very technical legislation, I think the political economy has had a big role, on how the law has evolved over the last few years. And this ordinance is, a direct result of the current political economy. And before the IBC was enacted, as some people might be aware, the law was heavily loaded in favor of the debtors, and the government consciously decided to move the pendulum to the other direction. And now the law is largely kind of loaded in favor of creditors, so to speak. Uh, and therefore, in this environment where a lot of people can, at least in theory, argue that their financial distress is largely attributable to factors which are completely beyond their control, it's not fair to have bankruptcy proceedings initiated against them. And especially in the Indian context, because our law, as some people might be aware, is a creditor driven displacement system where the promoters lose control of the process. They lose control over their companies, and an insolvency professional is appointed to run the company. So therefore, in a certain sense, the company is taken away, and this displacement can actually be permanent. And therefore, I think in this environment, my sense is, because of the political economy and the government, kind of, my sense is, wanted to give a message that uh, promoters should not be kind of thrown out of their companies if they're under financial distress because of the crisis. And possibly that's why they've kind of suspended it in the manner they have. I agree that section 10 uh, could have been saved, and that those proceedings could have been allowed. But the problem is that even if if you look at section 10 applications, it's very broadly drafted, and it's not just the company on its own, but also senior officials within the company who can initiate proceedings. So technically, the CFO of a company can file a case without board authorization. That's because that's how a corporate applicant is defined under the code. So so I think, in my assessment, in order to avoid situations where the shareholders and the board don't agree and senior officials want to file, uh, and given the fact this is a displacement regime, the government possibly decided to suspend the whole thing. But I, and also, we must not forget that even when a Section 10 application is filed, uh, the displacement can still be permanent, because when you do an auction in IBC, bidders will submit bids, etc. And then if the COC decides, and the company will be under the control of the person who submits the best bid. So therefore, it's unlike some other jurisdictions where the debtor continues to remain in possession of the company throughout. We just don't have that under our system, and possibly the government kind of thought that it might just make sense to suspend the whole thing.
So I think that pretty much covers what all it covers, and then there is another side of it, that what it does not cover, and probably we are yet to see some substantive measures on this side, which is the parties that section 7, 9 and 10 does not cover. These can be bondholders, and I read one of the articles on Vidhi itself about personal insolvency bodies. So is IBC in itself capable enough to cover them in such circumstances of COVID and the economic slowdown? And then we do not need such suspension for them, or we will need a separate mechanism for them altogether, which the government has not done yet.
Yeah, see, I think the code was intended to be a comprehensive legislation for the entire ecosystem. So it was meant to apply to both corporate debtors and individuals. So at least in theory, it applies to everyone. But in practice, the personal insolvency provisions have not been notified yet. And that's largely because the adjudicating authority for resolution of personal insolvency is the Debt Recovery Tribunal. And for those who practice, they might be aware that the debt recovery tribunals are already overburdened. And my sense is because of that, the government has been reluctant to notify the personal insolvency provisions generally, although they have done so for a limited class of individuals, uh, folks who have given personal guarantees to for corporate debt. Um, but I think in my assessment, because of the situation with DRTs at the moment, they have not been able to do so. But I think it's high time that the government kind of does something about it, because the law has been was enacted in 2016, and it's been almost four years, and we have not seen the personal insolvency provisions kick in. But on the corporate side, more or less everybody is covered. You mentioned bondholders, and I think bondholders do get covered under the definition of financial creditors under the code, and therefore they are actually eligible to file applications, and they also participate in the committee of creditors. Operational creditors, like trade creditors, suppliers, employees, etc., they can also file, but they don't have the same level of participation in comparison to financial creditors for decision making. But as far as their rights are concerned, they are also adequately protected, because there have been several amendments to the code which now ensure that operational creditors also kind of get their dues, in order of their, in accordance with the rights accorded to them in the order of priorities.
If we go through the ordinance, and one confusion which has been pointed out by few authors is the interpretation of the word ever in the proviso to section 10a. So, like, quoting this proviso for convenience, it says no application shall be ever filed for initiation of a corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. So, like, does that mean no CIRP for these defaults arising during such period, which seems not to carry much sense to me personally? So how do you interpret it and like feel coherency in it? Yeah.
Absolutely. So I think, unfortunately, this ordinance has not been very happily drafted, and there are some issues with it. And but if you look at the intent, that's very clear. If you look at the preamble to the ordinance, it clearly says that this is aimed at providing relief for a limited period for financial distress that is happening in this period. So I think the lot of we have spoken to a lot of practitioners, and everybody kind of seems to agree that this will not cover continuing defaults, in the sense that uh, if you have defaulted, and for instance, to give you an example, if the default is for about a lakh, and by the time this period completes you are not able to pay that amount back, then that default becomes continuing, which means that you can always file later, whenever uh, this exemption is lifted. So it's not that once you have defaulted you don't have to pay back this amount ever. So it's not like a free subsidy that the government has given. It's only a limited protection, that nobody, basically you can't be displaced in this period if you have defaulted during the 6 months for which the notification for which the suspension is applicable.
That makes sense. I guess like reading the entire ordinance together will bring more harmony in the entire ordinance as well. So now, like let's move further into IBC and economic slowdown measures, and focusing on Vidhi's recent work. So, in a recent briefing book titled Towards a Post-COVID India 25 Governance Challenges, Vidhi recommends that redesigning the fast-track CIRP might be an effective way of providing relief to the MSME sector. Now, what is the underlying reason that current fast-track CIRP is incapable to deal with the challenges of 2020? Like, is it the manner of initiating fast-track CIRP under Section 57, or it is non-exhaustive to deal with it, or anything else? Like, why do Vidhi feels that we need to redesign that?
So I think, at the time when the law was being designed, although originally, as I said, it was the first budget entry kind of referred to MSMEs, but then the law became, a very broad, the project became broader, and it kind of focused on everyone. But the law, in our assessment, is not kind of designed to address MSME bankruptcies, and it's not just us who have said that. The Insolvency Law Committee, which was set up to monitor the implementation of law, also kind of realized that we need to have some exemptions for MSMEs, and that's why they designed this Section 240A that allows the government to modify provisions of the IBC for the purpose of MSMEs. And I think there are two reasons for this. One, like most MSMEs are really by definition are small in scale, and therefore often the regular bankruptcy proceedings can be really expensive in proportion to the amounts at stake that some of these MSME bankruptcies involve. And secondly, these MSMEs, the way they operate, most of them operate through networks where the promoters know people who kind of supply you know necessary equipment, services, etc. To the company personally. And also the number of financial creditors are typically one or two, at max three. So it's a in terms of scale, it's very different from a large debtor which has multiple suppliers, multiple employees, and multiple financial creditors. So therefore very different, and therefore one need not need a highly process based expensive mechanism like the regular corporate insolvency resolution process. And most importantly, you don't have to displace the management in MSME bankruptcies. You can allow the promoter to remain in possession of the company while you're trying to resolve. And that's what we kind of propose in the briefing book also. And this is not possible under the fast track mechanism, because the fast track mechanism unfortunately also does not contemplate debtor in possession. That's also a displacement system, and the only difference is that it just provides for a shorter time period for resolution. Other than that, there is no major difference in comparison to the regular insolvency process. So therefore, so the two things that we suggest should change are basically move to a debtor in possession system for MSMEs, and also kind of try to see how do you kind of reduce the involvement of the adjudicating authority, because for MSMEs you need to try and find some kind of an informal solution, although should have the same legal sanctity as a formal solution. But as I said right at the outset, you can't make the process more expensive than the money or the amount at stake.
Talking more about reforms and your work in particular, so I was reading an article that you wrote for the print in July, where you discussed how the financial sector requires more than merely bailout packages for them to be effective. So recently the Supreme Court has directed that accounts not declared NPA as on August 31st shall not be declared NPA till further orders, and later that day only financial minister in a press conference said that the distress caused by the pandemic should not impact lenders' assessment. Are we not still observing, like talking about these two particular happenings which took place, and then talking in the context of your article, that are we not still observing ad hoc measures with no comprehensive policy which can cover employment regulation or monitoring bona fide use of packages, etc.?
In my assessment, both the courts and the government are kind of struggling to balance the interest of the debtors and the creditors. And while one might say that the Supreme Court, by saying that you can't classify them as NPAs anytime soon, kind of has said something in favor of the borrowers, but we must understand that from the government's perspective, they seem to be worried about both the borrowers and the banking community. And we must note that most of our large banks are public sector banks, so we are essentially talking about public money here. If on one hand, the government obviously wants the borrowers to kind of get out of this as soon as possible, but on the other hand, they can't let them kind of take advantage of this at the risk of the banking industry suffering huge losses, because as I said, it's indirectly the public which is funding most of our large banks, and there's a lot of money at stake. So it's a very difficult balance that they need to strike. And yes, there is a bit of ad hocism, so to speak. But in this environment, one can understand why this is happening, especially in a developing country where we obviously don't have uh, enough resources to kind of uh, bail out people left, right, and center. My sense is we are seeing a bit of that happening, and that's why we had, in that op-ed we had kind of argued for a separate mechanism for uh, doing this in a more organized and systematic way, where you because in some of the other jurisdictions the way they are trying to resolve this is by kind of doing direct bailouts and not moving through intermediaries like banks, and but the big risk there is that if in those cases it's very likely that that money will never come back. And in the Indian context, I'm not entirely sure if the government is in a position to roll out something of that nature, because most of the money will be public money, and we really don't want a situation where none of this actually comes back. So what we had proposed was a regulatory mechanism where you give this money out through through a well-designed statutory mechanism, where there is a monitoring agency that kind of oversees how some of this money is being distributed, and track how it is being utilized, and make sure that it's being utilized to generate positive cash flow and preserve jobs, and not kind of pay old loans, and which will only kind of exacerbate the debt overhang problem. Uh, but again, designing that kind of a system will also involve expenses, and in this environment I'm not really sure if the government will be in a position to do that. Maybe they can start with a small set of companies, maybe companies which are most adversely affected, or sectors that are most adversely affected, and then move on to others. But at the moment I think everybody is kind of uh, just reacting to the situations as they develop every day. And and there is a fair bit of ad hocism, but in my assessment this ad hocism is understandable.
So I have a last question for this podcast, which is like completely off the line with our discussion till now, and I'm personally interested to know your opinion on it. So in Swiss Ribbons case, where IBC's constitutionality was upheld for the most of the part, Supreme Court used the principle of manifest arbitrariness to declare that a mandatory time period of 330 days as fixed under the code for completion of the CRP as unconstitutional. So my question is, doesn't the use of constitutional principles on economic legislation bring more complications and may sideline technical ways to deal out with such challenges to provisions? Because there may be a situation, and as happened in this case as well, many are not sure if the constitutional principle in itself is correct. So there are more complications which arises as they get implemented on economic laws, because there are a lot of people who wrote articles and papers about how there was no need to apply for the manifest arbitrariness principle, and maybe harmonious interpretation of the entire code could have just worked out.
No, I agree with you that there were other ways of kind of achieving the same result in this case, and the Supreme Court arguably need not have used this doctrine. But we must understand that, especially for NCLT, we've had this huge history where it's been litigated for several years, and the Supreme Court upheld its constitutional validity after about 10 years of litigation. And a lot of this litigation had to do with separation of powers between the judiciary and the executive, and this entire and which also relates to this entire debate around tribunalization. So in this context, if you kind of see some of these observations, they start to make sense, because the Supreme Court has time and again said certain things to the executive which they have not complied with, and then the executive and keeps coming back to them with more. And in this particular case, they they in my assessment didn't like the use of the word mandatory, and therefore wanted to send a strong message, and that's why I used the doctrine. And but it's very likely that they could have achieved the same result by just kind of reading it down to say that this is in any case directory, and this terminology appears to be superfluous because of separation of powers and not necessarily unconstitutionality.
That was quite a good answer and instrumental in exploring more into this proposition, at least for me.
But I must kind of qualify that by saying that I'm not a constitution lawyer at all, and I'm essentially a commercial lawyer. So please take that with a pinch of salt.
But I think like that's the thing, right? We need to take opinions of everyone. A lot of constitutional enthusiasts have written a lot about it, so I wanted to explore it from the economic angle as well, and I think I've slightly received it, but I will more explore into the proposition. So lastly, a lot is anticipated and even happening in this area of financial law, and there is much to be explored and analyzed. So as the conclusion for the podcast, if you could share with us your new projects or ideas you're planning to pick up or looking forward to in future.
Yes, so we as you might be aware that the government has set up this insolvency law committee, and it's actually been in place since 2017 as a permanent committee which monitors the implementation of the code. And my understanding is that after the suspension kind of expires, the government might want to kind of understand how the insolvency system can actually help in mitigating the effects of this crisis. And world over, bankruptcy systems are being used for ensuring that viable businesses get rescued and unviable businesses get liquidated to cut losses for everyone. And I think if we are called upon to advise the government on that project, I think that will be one big thing that we'll be looking forward to, because that's going to be huge if at all that happens. And the two things that the government has announced that we are now looking forward to see when it finally happens is, one, the government had announced this separate scheme for insolvency resolution of MSMEs. It's not out yet. We don't know when that will be out. So it'll be interesting to see what they talk about there. And they've also set up a committee for insolvency resolution through a mechanism known as pre-packs, which is essentially an out-of-court mechanism with a certain degree of formality to give it the same legal standing as the regular proceeding. So we don't know what's happening there, but we understand that the government intends to kind of do something there as well. So we'll be looking forward to that piece also whenever that comes out. And that could also be very useful during the ongoing crisis, given the fact that now courts are not functioning in full capacity right now. So an out-of-court pre-pack mechanism could be really useful and efficient. So largely these three things, essentially.
I think those are really exciting ideas and much anticipated as well. I'm sure people interested in this field would love to follow up on your work there. So I think on that note, we can end this podcast. Thank you, Mr. Debanshu, for taking out time and sharing your views with us.
Thank you so much, Pranav. It was really good to have this conversation. When we are working on some of these reforms, we sometimes don't get the opportunity to kind of think through our own work in the manner we do when we have these kind of conversations. So really grateful to you for having me over for this.
Thank you so much. So thank you for listening to this week's episode of the IJLPP podcast. We really enjoyed talking to Mr. Debanshu about something very important happening in the financial sector and its regulation. We especially liked when he talked about the need to kicking the apparatus for personal insolvency bodies to look at the scope of intent to bring coherency in the IBC Ordinance 2020 and the cost and process analysis of MSME's CIRP requiring a new fast-track CIRP process. So for more legal readings, if you would like to reach out to us, visit IJLPP.com. We are into our 12th issue and volume 7. Issue 1 is now accepting entries. Check our website to know more details on submissions. We'll be seeing you next week. Thank you.
Thank you for listening to the podcast. Do not forget to check our website for more updates and legal articles. You can follow us on Twitter, Facebook, and LinkedIn. See you next time.